Great. Thank you everyone for joining us today. I always start out these webinars with my disclaimers. One, and especially with today's topic, which is, discussing nursing home Medicaid eligibility, is that everything that I'm going to tell you today is New York State specific. So if your loved one or your friend or somebody is in New Jersey or Connecticut or any other state, this is not going to apply. And if they tell you something from their state that sounds a little different, it's probably correct, but in their state, because what I'm going to tell you is very New York specific. Now, other states may have similar things, but they will not be exactly the same. So this is really New York based. The other disclaimer I'll give is that this is not meant to be legal advice. This is meant to be educational. My hope is that it's going to explain to you that things are not as obvious as they may seem. And I'll go through and I'll point out really the big takeaways in certain areas, because while we're going to talk about a lot of different things today, I don't expect any of you to know this in and out the way we do, because it's not part of your day-to-day life like it is for us. So that's all very important. Again, thank you to the Westhampton Beach Library for having us, and I'm just going to get started. So what is Medicaid? And we call it chronic Medicaid or institutional Medicaid. This is a type of health insurance that is a last resort health insurance that pays for the costs of being a long-term resident in a nursing facility. That's what we're going to be talking about today. And when I talk about it being a last resort insurance, it's because Medicaid is what we call the payer of last resort. So if you are a Medicare recipient, as most of our clients are, Medicare will still be your primary insurance. Medicare will be the insurance that will pay for the bulk of your care in terms of hospitals, doctors, etc. It is the Medicaid that is paying for the long-term costs of the facility if you have to live in one. And very often, just so you can quantify what we're really talking about here, is that many facilities, if we're talking about New York City out to Long Island, can be somewhere between $15,000 and $25,000 per month. So this is a very large cost. And Medicaid doesn't necessarily bear the entire cost, but what it does is, except for the exceptions that I'll talk about, the facility will take your income and Medicaid will pay the balance. So if you're someone who has $1,000 in Social Security payments and that's your only income, then that's going to be the cost to you of the facility. Whereas if you're a person with a robust pension and Social Security and other sources of income, then you may be paying $9,000 a month for the very same services that that other person is paying $1,000 per month. And then Medicaid is picking up the balance. So that's what we're talking about here. That's what we're achieving eligibility for, is that long-term stay in a facility. And very often it's the same facility. If you fall and you go to the hospital and you have surgery, or you're there for a week and then you're sent to rehabilitation, very often the same building that is a rehabilitation center is also a nursing home, a nursing center. And so those are the facilities that we're mostly talking about. Just because someone qualifies for nursing home Medicaid doesn't mean that they can't eventually go home and maybe transition, downgrade to what we call community Medicaid or home care Medicaid. And if somebody's on home care Medicaid and goes to a facility, they have to now qualify for the higher level, which is this chronic or nursing home Medicaid. So when we are looking to apply, we're looking at asset limits and income limits. Now, there is a look back period for nursing home Medicaid in New York State and in most states around the country. And it is a 5-year look back. So what does that mean? What are they looking back at? Well, they're looking back to see, did you give anything away? What did you give away? And as a result of giving that away, are you now not eligible for care because you gave assets away? Because there is a legal presumption that what you gave away was done for the purposes of qualifying for Medicaid. And there's certain exempt gifts you can give, and there are certain ways we can rebut that presumption or say to them, no, 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 you have it wrong. That wasn't why we gave this away. We didn't even know we were going to need Medicaid. And I'll talk about that as well. But really what we're talking about here is, did you give anything away? And if you gave it away, that's going to be a penalty. Now, there's probably people listening from different regions of the state, so we'll just use $14,000 as the number. It varies based on what part of the state you're in. And there's an annual chart that's put out by Medicaid to say what the important number is in that place. But for every $14,000, give or take, again, depending on your location, for every $14,000 that you give away, that's 1 month penalty. So if I have very commonly people say, oh, well, I gave a gift to my grandchildren because the IRS says I can give a gift tax free. Well, Medicaid isn't the IRS and they don't care about the IRS's rules. So if you gave away $28,000 over the past 5 years, that's a 2-month penalty. So that's 2 months that you need to pay privately for that facility, that $15,000 to $25,000, whatever it is in the facility you're in. And at the end of that 2 months, your penalty is up and you can then go on Medicaid and pay your income and Medicaid pays the balance. So that's what we're looking at. Now, the biggest takeaway, if you have to jump off this Zoom, if you got cut off, the biggest thing that I want people to take away from today is, it is very important, unless you are a person who has no money and no income, or very little money and very little income, and you hadn't given anything away because you didn't have anything to give away, it's usually worthwhile to at least speak with an elder law attorney who is knowledgeable in this area of chronic Medicaid when going into a nursing home, to make sure that there aren't any issues that might come up, and to make sure that you're saving as much money as possible. Because as you'll see, as I talk about today, it's not usually a lost cause for people that, well, I didn't plan 5 years in advance, so there's nothing I can do and I have to spend all my money until there's nothing left. That's not always and not usually the case. So it's really important that you seek proper legal advice from an attorney who can assist you or your loved one if you are in a position where you do need a nursing home. And sometimes people come to us and I review everything and I say, no, you're okay. You can just apply. There's nothing to worry about here. There's no money that has to be moved. There's nothing that has to be done. But a lot of people think, oh, well, I make too much and I have too much in assets and therefore I'm out. And I have no hope but to spend all my money. And that's not usually the case. So please do seek individual legal advice in those circumstances. So how do we become eligible? So this year, the eligibility asset test is $16,800. So if you have less than that in your bank account, you are eligible on the resource side. You're allowed to have a retirement account, an IRA, a 401k, a tax-deferred retirement account, as long as you are receiving distributions from that account. What your distributions are depend on exactly what part of the state you're located in, but as long as you're taking distributions from that account under your local rules, that account isn't counted as an asset for eligibility purposes. Now, you can also, let's see, what are we talking about, right? So some people have $15,000 in a checking account, but they have a whole life insurance policy with a $15,000 cash value. That person, for Medicaid purposes, has $30,000. They are over the limit. So we have to think about how we can make them eligible because they're over that amount with that life insurance policy. We are talking about your residence. So, the question of whether or not your home, when you now make the nursing home your new home, is your home exempt for eligibility purposes? Well, our goal is for people to protect their homes, to move it into a trust, to do so 5 years before needing the facility so the home's protected. But if that wasn't done, the home can be exempt if a spouse is living in it, a minor child, a certified blind or disabled child, or other dependent relatives. That home can be exempt for those purposes. We can also transfer the home out of your name. So if you own the home and now you need to make the nursing home your permanent residence, you can transfer without penalty. With that, there's that 5-year look back, but without penalty, you can transfer to a spouse, a blind or disabled child under the age of 21, a sibling with an equity interest. So if you and your sibling own the home together, and that sibling has to have resided with you for at least a year, or what we call a caretaker child. So if your child lived with you and under this presumption cared for you and kept you out of a facility by living with you for 2 years prior to going your admittance to the facility, the immediate 2 years prior to you going into the facility, the home can be transferred to that child without penalty. Now, if you don't have any of these things available, and maybe you need Medicaid to pay for the facility or help pay for the facility, but you really do want to return to your home, you can sign a document, a very simple document called an intent to return home. And what that does is it for a short period of time, 6 months or a year, again, depending on where you are in the state, it protects that home. It makes it so that that home is an exempt asset, and it makes it so that you can actually keep a little more income to help pay the bills of the home. And as long as you go home from the facility for 1 day, then any potential lien would be extinguished off of that home. So again, there's a lot of different options here, and I don't expect that anybody is going to be able to take this information today and apply it to a real situation. But it's important to remember that I'm naming just some of the creative ways that we handle things, but there are a lot of different ways that we can protect assets. So it's really important, if there are assets in the estate, to check in with an attorney if that has to be done. And I'm going to say that over and over again, because the importance of it is really huge, and it's really the key takeaway today. So a 5-year look back. So let's see, if we were talking about that around $14,000 number, give or take, what do you do if we have to, we have less than 16,800, we're okay. But if we have more than 16,800, are any of those assets exempt? So you're allowed to have a burial fund. You're allowed to have life insurance that's $1,500 face value or less. The idea is it could pay for funeral services, although I'm not sure it does. It's enough to do that. Reparation payments. So if you have reparations from the German government, for example, a lot of our clients do from the Holocaust, those reparations should be kept in a segregated account, and those reparations and the payments and the accumulation of them in a separate account are not counted as an asset. Certain retroactive Social Security payments might not be counted as a resource. And also for a lot of people, we will prepay a funeral with an irrevocable pre-plan. So for example, if somebody has $25,000 and we need them to be at $16,800, they can prepay and pre-plan their funeral. And as long as it's an irrevocable Medicaid approved funeral plan with the funeral home, then that money isn't counted, and that can get somebody underneath the limit. If we're transferring assets, so now these rules that I'm talking about are a little different than when we're talking about the home. If we're talking about cash assets or other assets, it's all exempt. All spousal transfers are exempt. So if spouse A needs a facility, we can transfer the assets over to spouse B, and spouse A can get the care, and spouse B has the money. So any transfer between spouses, there is no look back. There's no penalty assessed in that. To a blind or disabled child, or a trust created for that child, then certain other types of trust for a disabled person. And then we have the people who we just can't get under the limit. They've got $400,000 and we just can't get it so that they're at 16,800. There aren't these people that we can make the exempt transfers to, and we're stuck. So what do we do? Now I'm going to explain one of the most complicated parts. This is definitely a you shouldn't do this at home type of moment, but I'm going to share my screen for a minute so you can see something that we often do as a plan. Okay, so this is how we do Medicaid planning. Let me try and make it a little better. Okay. So what we do here is, you see, we have the monies in the Medicaid applicant's name up here on the top left, okay? And what we do is we have to give the money away, because if we want to apply for Medicaid as of November 1st, that person has to be underneath the 16,800 by November 1st. So if at the end of October, they have 400,000 in their name, we have to do something. We have to create eligibility in some way. So we give away all the money down to the 16,800. Part of that is a loan, and there's a promissory note, and part of it is a gift. This part is protected. Now, some people call this half loaf planning, but it's not exactly half, because as you'll see, there's multiple factors that go into how we determine the numbers. So that's why this isn't a don't try this at home. But just to show you the concept, part is a loan, part is a gift. This part is protected and not touched. So let's say, make it very simple for the sake of the example, mother-daughter. Mother needs Medicaid, daughter is only child and power of attorney and has a good power of attorney that allows her to do all these things. And so she gets this plan in motion. Now, we would have her gift the money in one check to herself. The other part would be given to her pursuant to a promissory note. That's the loan. And every month she would make promissory note payments, loan payments back to mom. That is income to mom. Mom would use the promissory note payment plus her Social Security, her pension, her required minimum distributions, if all these are relevant. And when you add all those things up, it would equal the private rate at the facility during the penalty. So what happens here is when we gave this gift over here, that created a penalty. So, say it was a $200,000 gift. Well, we take 200,000, we divide it by 14,000. That's how many months we have for a penalty. We then need our loan payments plus this other income to be enough to pay for that facility during however many months the penalty is. So at the end of the penalty period, we've saved a big chunk of the money, maybe 200,000, maybe more, maybe less, depending on these other income numbers. And we've paid for the facility, so there's no bill there, and Medicaid picks up. So we have some people who do this and they end up paying for a facility for 3 years because that's their penalty because of the amount of money they had. But at the end of that 3 years, we've protected a large portion of money, the bleeding stops, and they go on Medicaid and they give their income and Medicaid pays the balance. And so this is a very popular plan for people who have assets that need to be, that they want to save some of the assets and then use some of them for the cost of their care. Okay, so stop sharing. So that is a general idea. And that is the really perfect way of describing it's never too late, right? That person in my example didn't plan in advance. They had all this money in their name and it was time. They needed a facility. And so we had to create some kind of a situation where they weren't just going to have to spend all that money down until they were at 16,800. And obviously, if we have more money, the way the math works is we can save more money. And if you have more income, then we can save more assets because we don't need the promissory notes to be as large. And so it's a delicate balancing, and we put that formula together. So now I want to talk about spousal refusal. So spousal refusal is when one spouse takes all the money and then says, I have money in my name and I can't use it for the benefit of my spouse because I need it for myself. So it can be that one spouse needs Medicaid and never had money, and the other spouse always was the one who had the money and they never shared finances. That happens. Or it could be that everything was joint, and when this person got sick, they gave everything to this person. And so it can be in those different situations that one spouse ends up with money. But the reason that spousal refusal is necessary is because a spouse is a legally responsible relative. So if I'm married, I must provide for my spouse. I am legally responsible to provide for them. And so what you're basically telling the state is, no, I'm not going to abide by my obligation to care for my spouse because I'm afraid I'm going to impoverish myself and I need to take care of myself. And that is a perfectly valid thing here in New York State. Again, very different other places. And so this is where your location is really going to matter. So depending on where you are in the state, some counties seek recovery from spouses who refuse and others don't. In the counties that don't, I can take any amount of money and give it to my spouse who's not going on Medicaid, and they can use that money for the rest of their life as they see fit, and there's not going to be a recourse against them currently because their county does not seek that type of reimbursement. Whereas other places, like here in New York City, where I'm sitting today, in our 5 boroughs, there is a department of the New York City government that actually seeks reimbursement from a refusing spouse that has more than the spousal allowance limits. And then we have to create negotiations. The rule is that if a spouse is allowed to have $3,435 per month in income. So if a spouse has more than that, the county can ask for a monthly contribution of 25% of the overage. So if I have a $4,000, a spouse with $4,000 worth of income, then the county can ask them for a quarter of the difference between $3,435 and 4,000. So, about $120 a month or something like that. So $125 a month is what you're going to contribute for your spouse to get their care. And obviously spouses who have more income, they're going to be asked for a larger contribution. And again, we often will negotiate with the city to try and make it as easy as possible for the other spouse to continue to provide for themselves so that all their money is not going to go, if they need it, to the cost of their spouse's care. In any case, you are getting the care at the Medicaid rate. And so, Medicaid pays a lot less for a facility than you would individually. So even in New York City, where we really deal with this refusing spouse recovery issue, it's often worthwhile for the refusing spouse because they're getting a lower rate and they're paying at the Medicaid rate when they do have to recoup money. For assets, so that the income is a quarter of the overage. For assets, the limit is just over $137,000. And if you have more than that, then they will come back and ask you to contribute what the cost of the care is for the spouse. And again, we can work with the city to try and reduce that number as much as possible. So all that being said, what can people do to plan? So I mentioned it before, and I'll mention it again now, having a really strong, robust power of attorney. So you may not be ready to move assets out of your name. It might not be time to start that 5 years ticking for the look back or transfer assets, but you do want your power of attorney. If you have someone that you trust to do so, you want them to be able to do all of that planning that I just discussed. So your power of attorney needs to let them do promissory notes, transfer assets as a gift, create trusts, transfer assets into trust. And if the power of attorney document doesn't specifically allow all these different things, you might name someone as your agent under power of attorney, but you haven't actually given them the power to do it. So it's really important that at the very least, you have a robust power of attorney document if this is something that might come up down the line. You also want to make sure that if you have a spouse, and especially if your spouse is going on Medicaid, that your estate planning documents are reviewed and updated to make sure that you're not going to end up that if the person, one person gets sick and goes to the nursing home, that doesn't mean they're going to die first, right? The person who's at home, who's the healthier person who can stay at home, may actually be the first to die. And you don't want all the money just going right back into the hands of the Medicaid recipient. So we need to do planning around that. And then we do trusts. What these are Medicaid asset protection trusts. So let's take your home, right? That's often a very easy thing for people to put into a trust. We can do it with co-ops as long as the co-op board, and if there's a mortgage, the bank allows, but with a house or a condo, we just have to do a deed. And what we do is we create a trust. Someone other than you or your spouse have to be the trustee of that trust, so have to be in charge of it. And then it remains yours for tax purposes. So if you get the veterans exemption, star exemption, enhanced star exemption, all of the tax purposes, it's yours. You are responsible to pay all of the maintenance and upkeep of the property. That doesn't change. But upon your death, it says where those assets go, just like a will would. And it makes it so that those assets are not available to you if you apply for Medicaid for the nursing home 5 years after creating the trust. So I create the trust, I sign the deed putting my house into the trust, or the co-op transfer putting my co-op into the trust. I wait 5 years, and at 5 years and a day, I can go to a nursing home and ask Medicaid to discount that property as my asset. So that's very important planning. Now, we can also put properties, other things than properties into the trust. We can put cash into the trust. You can put an investment account. So say somebody puts an investment account into the trust, they can receive the interest and the dividends if they want, depending on how we write the trust document, but then they can't receive principal. So this is the number one thing that I think people get confused about with these trusts is if you put money in the trust, you're not putting in it so you can use it later. You're putting money in the trust to protect it so that you can't use it, and that Medicaid will pay for things and not come after your money so that you can pass your money on to others. So a lot of people come to me and maybe they are single and they don't really, you know, if money goes to their niece, they're perfectly happy for it too. But if they need every dime of it during their life, they're very happy for that too. That might not be a great candidate for this type of planning, because that person might not want to lose the control or use of their own money for the benefit of saving it for the next generation. Whereas somebody who has children, grandchildren might feel strongly that money be put aside and protected so that it can pass on. And so a lot of this is going to be very person specific. You can put a secondary residence into a trust. So if you have a residence that you rent out, or maybe you have a summer home, or you know, a lot of our clients maybe are renters in the city in a rent stabilized apartment, but then they have a small little cottage somewhere else or something like that. You can put those assets into the trust as well. And then at death, like I said, it can continue for the lifetime of your spouse. And then when you're both gone, it can pay out to whomever you've named as beneficiaries. And the good news is, if you've listened to any of our probate or estate planning basics seminars, you'll know that when you have a trust, when assets are in a trust, you avoid the court process of probate. And the court process of probate is not just timely and expensive, and there's all the other issues with it. But if you're on Medicaid, Medicaid can put a lien on anything that goes through probate. So if you create a trust and all your assets pass outside of the court through the trust without probate, Medicaid can't put a lien on your property, and it will all go to your named beneficiaries, not to Medicaid. Okay, so let's see if we have any questions here. Does spousal refusal only apply to those seeking nursing home coverage? No, spousal refusal applies for the home care Medicaid context as well. Spousal refusal is a global Medicaid. By global, I mean across the board Medicaid in New York State concept, that one spouse can refuse to care for the other and keep the assets for their own use. Does Suffolk County seek recovery? I have not yet seen that. Anything could happen because every county has equal rights, but I'm not currently seeing that. I always, especially when we're talking to a Westhampton crowd, it's never clear. Sometimes we have people listening who one place or the other as their primary residence, but they actually go back and forth between the two. I should point out that the county of responsibility to pay for your Medicaid services is the county where your primary residence is. And so let's say I live in Manhattan, and then I go to the hospital, and when I'm actually placed into a nursing facility, a rehab, and then nursing facility, I go to Queens. It is, or I should say I go to Nassau, then it will be New York City HRA that is responsible to pay for my Medicaid in the nursing facility, because that's my county of residence, not Nassau, where I was placed in a facility. What's the difference between spousal refusal and spousal impoverishment, and in what instance could you use one versus the other? So spousal impoverishment budgeting has to do with when the spouse who might be refusing, right? So you might refuse because you've got $100,000 in your name, and therefore you have more than the 16,800. So you can't go under regular budgeting because spouse A can have 16,800, spouse B has 100. So you might be refusing for that purpose, but the spouse who has 100,000 might not have any income. So let's say, let me do some numbers. Let's say that spouse A, who's going to the nursing home, has $4,000 a month of income. And spouse B, who's at home with the $100,000 in their name, has $1,000 per month in income. This budgeting allows, instead of the one who's in the facility giving all $4,000 to the facility and Medicaid paying the balance, the person at home can keep their own income, the $1,000, plus enough of their spouses to bring them up to the $3,435. So if I have 1,000, that means I can get another 2,435 from my first spouse. That's that much less goes to the facility, and the spouse who's at home gets to keep that higher budgeting. So whether or not you're using spousal refusal, spousal impoverishment, or both, it's just a numbers question. It just has to do with what assets and income are in each person's name, and then how do we have to make the one person eligible. Amount of protected gift limit. There really isn't an amount. So it's more who the gift is given to that determines if it's protected or not. All gifting can be counted. So if you gave 10 $2,000 gifts, that over 5 years, that's a $20,000 amount. So that's a month and a half of ineligibility. So there is not a set amount. Different counties have different kind of rules of thumb, usually between, $1,000 and $3,000 of what they'll actually actively ask for, but they can always ask for more information if they want to see what a specific transaction was for. Because I should say, when you apply for a 5-year look back, you give 5 years of tax returns to show all your accounts, and you give 5 years of every statement. So if I get 12 statements a year of my checking account, I am giving 5 years of 12 months of statements. So our Medicaid applications are often going in like this in multiple FedEx packages, because it's a very big app. It's an application, but the supporting documentation is really robust. So for every gift that's given or every transaction, we have to show not just the bank statement showing the transaction, but the check, the withdrawal slip, the deposit slip, to show the backup for that transaction. So it's really a lot of work if there's a lot of movement in your accounts. Again, if you have a more simple picture where you have one account and your Social Security came in and you spent it, and then every month it came in, you spend it, came in, you spent it, that's gonna be a very simple Medicaid application. You send 5 years of those bank statements and you're in the clear. So if a property is in a life estate, so we generally don't recommend life estates anymore for a lot of reasons. But to answer this exact question, what if a property is in a life estate? So if I have a deed to a property and I give my property to someone else, but I reserve a life estate saying it's mine for my lifetime, and that's actually written in the deed, then 5 years after I do so, that can be counted as, or discounted, it's not counted as an asset for Medicaid eligibility. The issue becomes if that property is sold because I've moved out of it, depending on my age and the month that it's in and the federal rates and the value of the property, if that property is sold and I'm still alive, I own a percentage, my life estate is worth something, and that might require a turnover of some of that, some or all of that money to the nursing facility. So we try to be very careful not to do life estates because it doesn't protect 100% of the property. We really would prefer a trust in those circumstances. There's a question here about assets being moved from a person moving from Florida to New York, and whether or not the documents need to be changed. I would say that that is worth a consultation with an elder law attorney to have the documents reviewed to see if they should be changed or updated, depending on the terms of the documents. I generally recommend that anybody living in New York State have a New York State power of attorney, because our power of attorney law is so specific that it's often difficult to get other states, other banks to accept other states' documents, and other states' documents might not have the detail that we have. So I definitely recommend that if someone's moving from state to state, whether it's Florida to New York or New York to Florida or somewhere else, that your documents be reviewed by an elder law attorney to make sure they still will accomplish your goals in that new state. There's a question about the co-op. So what I'll say with a co-op is you want to check a few things. You want to see how the stock is held. Two people's names on a co-op does not mean that it goes to the survivor of the two. It only goes to the survivor of the two if it's joint with rights of survivorship. So if it says mom and daughter own a co-op together, and it doesn't say joint with right of survivorship, and mom dies, mom's share would have to go through probate, and Medicaid could put a lien. So you want to be very careful and have your co-op shares reviewed to see how the document is written to make sure that the survivor of the two is protected. So thank you everyone for joining us, and thank you again to the Westhampton Beach Library for bringing this to you today. And I look forward to seeing you all in the future, hopefully in person soon. Have a great day.